All right, let's get to something more fun, everyone. So there's been a conclusion in the case of comedians in cars drinking coffee. At least I think that was the title of it. Comedians in Cars Getting Coffee. You might remember that Christian Charles had sued Jerry Seinfeld, claiming that he had some sort of copyright ownership in the concept or expression of the Comedians in Cars Getting Coffee idea. I have a video on it. I'll put a bubble up there so you can watch that. It's actually been a little while. This case is from 2018. The parties have been fighting over the attorney's fees and costs, and now Seinfeld's attorneys, Seinfeld having won the case, that Christian Charles does not have a claim to the copyrights, both because he waited way too long. I think his claim was back in the early 20-teens, and copyright has a 3-year statute of limitations, so he waited too long, and there was that statute of limitations / latches defense. There was also a contest, the valid contest, over whether he actually had any copyright to begin with at all, even if he lost it based on not claiming in time. I don't think the court agreed that he had any claim in the beginning at all anyway. So, under 17 U.S.C. 505, Seinfeld would be due his fees and costs. And this decision is a decision finding those fees and costs way too excessive. The Fogarty versus Fantasy case is a Supreme Court case that defines what attorneys' fees and costs are to be granted in these fee-shifting cases, and those fees have to be reasonable fees. They can't be excessive fees. The court will pick it up from here and tell the story, and I think you'll really enjoy this one, so listen up. This is in the United States District Court for the Southern District of New York, Christian Charles versus Jerry Seinfeld, the Memorandum, Opinion, and Order by Allison J. Nathan, District Judge. Before the court is defendant's motion for attorney's fees and costs under 17 U.S.C. 505. The court, on February 26, 2021, ordered Charles to file a brief to address the size of fees requested by defendants, which amounted to $873,000 in fees and $101,000 in costs, a total of $974,000. For the reasons that follow, the court awards defendants $28,750 in attorney's fees and $92 in costs, a total of $28,842. The court further concludes that Charles's counsel is jointly and severally liable for the payment of this award. That's usually not something that happens. Usually, except in Leibowitz cases, usually the attorney is not complicit in the incurring of an attorney's fees and costs shifting award. So this is going to be interesting. Background. The court presumes the parties' familiarities with the facts of this case, which are explained in greater detail in the court's prior orders and our video, and Judge Parker's report and recommendation. In brief, plaintiff Christian Charles, an award-winning writer, director, and producer, alleged copyright claims against Jerry Seinfeld and several related defendants related to the show Comedians in Cars Getting Coffee. The court ultimately dismissed the second amended complaint on statute of limitations grounds, explaining that Charles was on notice of his claims since at least 2012, but did not file suit until 2018, far outside the 3-year statute of limitations on such claims. Defendants, represented by the law firm of Gibson, Dunn, and Crutcher, filed a motion for attorney's fees under 17 U.S.C. 505 on October 15, 2019, a motion that the court denied with leave to refile pending resolution of Charles's appeal of the court's order. The Second Circuit affirmed dismissal of Charles's claims on June 18, 2020. Upon additional briefing of the motion for attorney's fees, Catherine H. Parker, magistrate judge, issued a report and recommendation recommending that the court deny defendant's motion in significant part because Charles's claims were not objectively unreasonable. Remember, we found out about the objectively unreasonable requirement with the Akilah Hughes versus Carl Benjamin case, the "we thought she would win" case where he made use of her video. It turned out to be a fair use, and there was some controversy about that. But in the end, the court ruled that Akilah Hughes' position was objectively unreasonable and awarded Carl Benjamin's attorney's fees and costs to be paid to him from Aquila Hughes. And then she raised the money for that, so I guess he got paid. The court on February 26, 2021 sustained defendants' objections to the report and recommendation, concluding that Charles's claims were objectively unreasonable and that other relevant factors favored awarding defendants' attorneys' fees. Because Charles had not disputed the size of defendants' requested fees and costs in its briefing or oral argument before Judge Parker, nor in its briefing to this court, the court ordered Charles to file a brief on the amount of the fee award, with particular attention to the relative financial strength of the parties. Charles filed a brief on the size of the fee award on March 12, 2021. Defendants filed a response March 19th in which they requested that Charles' counsel be held jointly and severally liable for the fees. The court then received further briefing from both parties on the issue of joint and several liability of Charles' counsel. Last, the court on December 21st, 2021 ordered Charles to submit by December 27th Charles's financial documents referenced in his brief and attached declaration. The court received those documents under seal. Though the court expressly instructed Charles to file a brief not to exceed 10 pages addressing the size of the fee award, Charles devotes much of his brief to relitigating the court's conclusion that his claim was objectively unreasonable. First, Charles argues that defendants have not presented affirmative evidence of copyright ownership, yet at the motion to dismiss stage, defendants had no burden to present such evidence. And Charles's failure to file suit within the statute of limitations bars his suit from proceeding into discovery. Second, Charles refers to the Sixth Circuit's decision in Everly versus Everly. The court refers back to its prior conclusion that Everly is entirely consistent with the Second Circuit's holding in Quan v. Schlein, and that neither case provides a reasonable basis for believing that Charles' action was timely filed. Third, Charles argues that the fact he received repeated warnings of the basic flaw in his claims does not justify fees. Yet such warnings are an important factor under Section 505 fees provisions, which encourages parties with strong legal positions to stand on their rights and deters those with weak ones from proceeding with litigation. And fourth, Charles contests the court's conclusion that the suit was opportunistic. The court concludes, however, that Charles's suit filed over 5 years after his ownership claim was repudiated, at the same time that defendants completed a multi-million-dollar deal with Netflix, reflects opportunistic litigation, even if Charles's attempt to first resolve the dispute outside of court provides some mitigation. The court therefore denies Charles' requests to reconsider its prior order. On to the fee. A district court exercises considerable discretion in awarding attorney's fees. The party seeking fees bears the burden of demonstrating that its requested fees are reasonable. Both the Second Circuit and the Supreme Court have held that the lodestar, the product of a reasonable hourly rate and the reasonable number of hours required by the case, that creates a presumptively reasonable fee. The court will first evaluate the reasonable number of hours required by the case, and then will turn to the reasonable hourly rate before calculating the resulting reasonable fee. An analysis of hourly rates turns on what a reasonable paying client would be willing to pay, given that such a party wishes to spend the minimum necessary to litigate the case effectively. Generally, an attorney's customary billing rate for fee-paying clients is ordinarily the best evidence of a reasonable hourly rate. As to hours, the court conducts a conscientious and detailed inquiry into the validity of the representations that a certain number of hours were usefully and reasonably expended. This usually takes the form of a proper hourly log. So you keep a time log when you're working on an hourly basis, and then you have to submit that time log. Every entry in the time log should have the number of hours expended, preferably kind of like a time card, like a clock in and a clock out, as well as a good description of what you did during that time. You don't have to submit attorney-client privilege information, so we attorneys are trained to make that log as sort of a general description of what we were doing. Researching this issue in this case, had a telephone conference regarding these issues with client. You don't have to say the details of what was discussed, but you do have to give the court and the opposing party notice of what you're billing them for, basically. In determining whether hours are excessive, the critical inquiry is whether, at the time the work was performed, a reasonable attorney would have engaged in similar time expenditures. In calculating fees, the court also looks at the nature of the legal matter. Complex cases justify higher rates and more hours and resources, while simpler cases justify less of each. Despite several opportunities to do so, Charles has repeatedly declined to contest the basis of defendants' requested fees. Nevertheless, the court has an independent obligation to conduct a conscientious and detailed inquiry into the reasonableness of the fee award. This is really lucky on the part of the Charles defendants, because failing to contest high fees like this, that's really a no-brainer. That's probably some kind of malpractice there, in my opinion. I'm certainly not accusing anyone. I don't know every detail in this case, but that seems indefensible that you wouldn't contest nearly $1 million in fees and costs when the case was dismissed at the beginning in the motion to dismiss stage. No one should be spending $1 million on a motion to dismiss a basic copyright issue. I think that's what the court's going to be getting at here. So the defendants, they got a pass here. The court did their job for them, and that's not usually what happens when there is a defendant who is represented by an attorney. What could have happened here, just to give you an idea, the court could have found that the lack of a defense leaves the number in place and awarded the $29,000 fee shifting against defendant Christian Charles himself, and the rest of the $1 million in fees against the attorney. I'm glad the judge didn't do that, but I think that was within the judge's power to do. Defendants requested a staggering $873,000 in attorney's fees and $101,000 in costs. That fee amount is constituted by 1,466 hours of work completed by 8 attorneys, as well as paralegals and support staff at Gibson Dunn. These individuals include Orrin Snyder, a senior partner at the firm and co-chair of the firm's Media, Entertainment, and Technology Practice Group. His standard hourly rates were $1,400 an hour in 2018, $1,445 in 2019, and $1,550 in 2020. David Kuznets, a 6-year litigation associate at the firm who had day-to-day responsibility for this matter. His standard hourly rates were $815 in 2018, $895 in 2019, and $965 an hour in 2020. Matthew McGill, a partner at the firm who assisted on the appeal in this case, his standard rate was $1,320 an hour in 2020. Lauren O'Boyle, a junior partner at the firm, defendants are not seeking the reimbursement of fees performed by O'Boyle. First-year associates, Jeremy Bunting, Trevor Gopnik, Kimberly Kirschenbaum, Amanda LaSavage, and Zachary Piaker, whose hourly rates ranged from $545 an hour in 2018 and $650 in 2020. Those are first-year associates. That is much too high for a first-year associate. I don't even think $250 an hour is appropriate for a first-year associate, but I guess we'll see what the judge has to say. 3 paralegals, whose rates were $390 an hour in 2018, $405 in 2019, and $424 or $431 in 2020. 4 litigation support staff billing from $200 to $300 in 2018, $200 in 2019, and $210 in 2020. And a managing attorney with an hourly rate of $443, $461, and $440 in 2020. Defendants provided the educational and professional background for their attorneys, but not for their paralegals or support staff. On the rates issue, according to the Kuznets declaration, the rates listed above are those actually charged and paid by Gibson Dunn clients for comparable work. That weighs in favor of finding the rates reasonable, but is not dispositive. Defendants cite in support of their requested rates several cases in this district that awarded similarly high rates for Gibson Dunn attorneys, yet these cases are not copyright cases. One was a breach of contract action, another was a breach of contract action. In copyright cases, the rates deemed reasonable in this district are lower than those sought by defendants. The court cites to a couple of copyright actions $750 an hour, $465 per hour, $200 an hour, $913 an hour, $750 for a partner with 20 years experience, $913 per hour for a partner with 40 years experience, $400 per hour for an associate with 5 years of experience, and $150 to $200 per hour for paralegals and litigation support. Partner rates have ranged from a low of $400 to as high as $913. Courts have found associate rates between $200 and $575 to be reasonable in copyright cases. Courts in this district generally find that reasonable hourly rates for paralegal and litigation support staff range from $150 to $250 per hour. Courts often reduce hourly rates for paralegals when no information was provided as to their experience or expertise. In this case, based on the prevailing rates awarded by courts in this district, the extensive experience and reputation of Gibson Dunn, the Gibson Dunn is a reputable law firm from everything that I've read and heard, so I have nothing bad to say about that, just that I'm aghast at these extremely high rates. And the information provided about the attorneys who worked on this matter, all of whom have strong credentials, the court awards the following rates to counsel who worked on this case. $875 to $925 for Orr and Snyder, $400 to $450 for Kuznets, $800 to McGill, $270 to Bunting, $250, $275 to Gopnik, $270 to Kirschenbaum. Yeah, these are the first-year associates, and those rates are much closer to what I expected. Because no information was provided to the court about the experience and education of the legal support staff, the court awards a rate of $150 per hour for support staff and $200 per hour for paralegals. Hours. Defendants requested 1,466 hours of billed work, excluding any work performed by Summer Associates and partner O'Boyle. Partners Snyder and McGill, who have the highest billing rates, performed 6% of the billed hours, associate Kuznets about 57%, the junior associates about 32%, and paralegals and support staff about 5%. Though defendants properly assigned the bulk of the legal work to associates rather than to senior partners, the court concludes that the volume of hours billed is excessive by any measure. Hours that are excessive, redundant, or otherwise unnecessary are to be excluded, and in dealing with such surplusage, the court has discretion simply to deduct a reasonable percentage of the number of hours claimed as a practical means of trimming fat from a fee application. A few examples demonstrate the excessive nature of the hours billed. Let's have a quick exercise and let's see what the docket in this case looks like. So here is the docket. We have a complaint on February 9th, 2018, summons issued to the various defendants, case management conference, affirmation of service, and then somewhere along here there should be a motion to dismiss. Extension of time, adjourned conference, first amended complaint, then we have June 29th motion to dismiss the first amended complaint. So you've had less than 6 months worth of activity here, most of which was on the plaintiff's side, and then whatever research they needed for a motion to dismiss. Lots of extensions of time. This wasn't the pandemic yet. A second amended complaint was granted, and then a motion to dismiss the second amended complaint September 17th, 2018. You shouldn't have to completely rewrite your motion to dismiss. You should address whatever the second amended complaint changed, and then file basically the same document with additional information addressing the amendments. It's really not that hard. It shouldn't take thousands of hours. I don't want to accuse anybody of anything, but I'm kind of wondering if, because Seinfeld is a high-value client, maybe they just did a lot of work on his case because they could. It's not something that I know for sure, and I'm certainly not accusing anyone of any unethical behavior. It's just a sneaking suspicion that attorneys will intentionally put in more hours for clients who are paying higher rates and can afford to do so. The opposite is true as well. Attorneys will try to intentionally limit how many hours they put in if they're trying to work with their clients and controlling costs. It's literally called cost controls, and it's a perfectly valid way to conduct your case. So it kind of works the same in both ways. So there's a lot of stuff going on here, but most of this seems to be extraneous stuff that's not really addressing the motion to dismiss. It seems to be more case management stuff that's going back and forth here. So then finally we get an opinion and order September 30th, 2019, and a judgment and an appeal. Obviously, there will be some incurring of hours on the appeal as well. And that can be expensive. Appellate attorneys are usually more costly than district court attorneys. So yeah, it's possible to incur a pretty good amount of fees in this case. I'm still questioning 1,466 hours of billing. A few examples demonstrate the excessive nature of the hours billed. First, take the series of motions to dismiss that defendants filed. The lead associate, Kuznets, alone billed 120 hours to research and draft the initial motion to dismiss. Keep in mind there are 168 hours in a week. 40 hours is considered a normal amount of time to work in a week. Attorneys usually, for these upper tier law firms, can be expected to put in 60 to 80 hours a week. I've heard of numbers as high as 100 hours a week. So Kuznets is putting in basically full time for 3 weeks, or a rather excessive number compared to 40 hours a week in like a week or two. So this is like Kuznets doing nothing else for 3 weeks. An additional 130 hours to update the motion following the first amended complaint. Like I said, that shouldn't be necessary to update for an amendment to a complaint. It shouldn't be a wild amendment. It's going to address some things, and I don't see why you would need 130 hours to update an already written motion. And a further 37 hours to update it following the second amended complaint. And partners and junior associates also billed hours to contribute to and review this work. The court finds substantial overlap in the authorities across the 3 briefs filed in support of the motion to dismiss, suggesting that the hours billed to modify later briefs were in large part unnecessary. And the approximately 180 hours spent by associates to analyze Charles' response and to draft a reply exacerbates the issues. At bottom, given the straightforward statute of limitations defense at the center of this case, defendants' request of $300,000 for drafting just the moving briefs alone is plainly unreasonable. Second, between their 2 motions for attorney's fees, the first prepared in September of 2019 and the present motion in May of 2020, defendants request fees for more than 150 hours of work. Courts in this district typically find that motions for attorney's fees should not exceed 30 hours, even in cases more complex than this one. Third, the records reflect hours billed for multiple attorneys, including junior associates, to attend a mock argument and oral argument. Typically, courts do not pass the cost of associates observing mock arguments or oral arguments onto the opposing party in a fee award. Excessive billing for relatively straightforward matters is repeated across this case, including for initial disclosures, seeking a stay, mediation, brief and appendix formats, oral argument preparation, and the actual decisions issued in this case. The excessive research time warrants a substantial reduction in hours, and they cite to the John Wiley & Sons case, the Dummies Book case, reducing hours in a fee award for excessive research time. Further, defendants submitted records to the court that involve block billing. That is, the attorneys did not sufficiently disaggregate their time description to permit the court to determine the time spent on individual tasks. Remember I said you need to make an adequate description of each individual block of time that you have made? Well, they've engaged in not an adequate description, is what the court is saying. Block billing, although disfavored, does not automatically preclude recovery for the hours billed by counsel. Courts make reductions to block billed hours in circumstances when there is reason to believe that the hours billed were independently unreasonable, that the block billing involved aggregating tasks that were not all compensable, or the number of hours block billed together was so high, such as 5 hours or more, so as to create an unacceptable risk that the aggregated total exceeded the reasonable hours worked on compensable task. Here, the first and third factors are present, which justifies a reduction in hours. The court has broad authority to make across-the-board percentage cuts in hours as opposed to an item-by-item approach to arrive at the reasonable hours expended. Courts in this district have applied percentage reductions of up to 50% to address overbilling issues driven by case and billing specifics. In making its determination of a percentage reduction to be used, the court is guided by the principles of rough justice. Trial courts may take into account their overall sense of a suit and may use estimates in calculating and allocating an attorney's time. The court therefore reduces defense counsel's hours across the board by 50%. So the judge cut the 1,466 hours to 733 hours, I guess. Section 505 permits the recovery of full costs by the prevailing party. Generally, courts award reasonable out-of-pocket costs incurred by attorneys and charged to their clients. An award of costs normally includes those reasonable out-of-pocket expenses incurred by the attorney and which are normally charged to fee-paying clients. Defendant's request of $101,000 in costs is made up of $66,000 for electronic legal research, $33,000 for electronic discovery database hosting fees, and $1,300 for in-house duplication charges, and $500 for postage, messenger, and courier delivery services. The court will not award costs for electronic research fees, which are already accounted in the attorney's hourly rates and research time. The cost of the computer service used in the research is no more reimbursable than the cost of the West Keynote Digest and the volumes of federal reports and the federal supplement that lawyers used to use, and many still use, to find authority and research issues of law. Similarly, the electronic database hosting fees are very high and not properly imposed on Charles in a case that did not proceed to discovery. Defendants, of course, had an obligation to preserve relevant documents for discovery, as did Charles, but both sides bear and typically retain that cost. By contrast, copying costs are typically recoverable, yet defendants do not explain exactly what was copied and why, especially as paper copies become less and less necessary. For example, it appears that some copying was done to create litigation binders. The court will reduce copying costs by 50%. Postage and messenger costs are similarly recoverable by default, but defendants do not explain why a messenger and overnight mail was required rather than, for example, first-class mail. The court reduces these costs by 50% as well. Based on the above analysis, the court concludes that a presumptively reasonable fee for defendants based on the lodestar method is $287,500 in attorney's fees. The hourly rates determined above multiplied by the hours listed in the Kuznets Supplement Declaration, Exhibit B, and $920 in costs, $654 for copying, and $266 for mailing and delivery. Then the court reduces it further. Even after the presumptively reasonable fee is calculated, a fee award may still be adjusted based on the relative financial strength of the parties. Ultimately, the fee award must be tailored to the goals of Section 505, namely, to advance considerations of compensation and deterrence. The court may consider the defeated litigant's economic circumstances to determine whether a lesser sum assessed would fulfill the statute's deterrent purposes without subjecting the losing party to financial ruin. The financial disparity between the parties is glaring. Charles initially pursued this case pro se and has been represented by two sets of counsel on a contingency basis. In other words, he has never paid attorney's fees. According to his sworn declaration, Charles's income completely collapsed following the events at issue in this case. In the 4 years preceding this suit, Charles reported income totaled just $1,000. He further attests that he has no liquid assets. Charles's financial record submitted to the court under seal confirms these statements and that Charles's financial situation is indeed precarious. Defendants do not dispute these facts. By contrast, defendants are well known and financially thriving. Plaintiff attaches to the declaration of Mr. Charles a collection of media sources that estimate defendants' net worth and revenues. The defendants do not contest these numbers, and the court finds them to be consistent with defendants' public securities filings. Simply put, the difference between the parties' financial resources is vast. Defendants argue that Charles's financial position does not negate the need to award fees to satisfy the ends of compensation and deterrence. The court agrees so far as this argument goes. As the court previously stated, Charles' pursuit of opportunistic and baseless claims requires substantial deterrence. Some degree of deterrence is especially necessary here because Charles received repeated and correct warnings that his claims were time-barred and that defendants would seek a fee award. Charles' conduct reflected, as defendants describe it, a sense that he had nothing to lose and everything to gain in pursuing this litigation. But the court must further assess whether, in light of plaintiff's ability to pay, a lesser sum assessed would fulfill the statute's deterrent purposes without subjecting him to financial ruin. Joint and several liability of counsel. Defendants also argue that the financial burden on Charles should be reduced by holding his counsel jointly and severally liable for the fee award. The authority to grant this request derives from a court's inherent power, which allows it to impose monetary sanctions against a litigant or its counsel for misconduct. To hold counsel liable for fees owed by their client, a court must make two findings. First, that the challenged claim was without a colorable basis, and second, that the claim was brought in bad faith, i.e., motivated by improper purposes such as harassment or delay. The first requirement means that the claim lacks any legal or factual basis, and bad faith may be inferred when an action is so completely without merit as to require the conclusion that it must have been undertaken for some improper purpose. For the same reasons articulated in its prior opinion that Charles's claim was objectively unreasonable, the court finds that Charles's claim lacked a colorable basis. Indeed, Charles all but concedes that controlling Second Circuit precedent squarely foreclosed his claims. And Charles's conduct not only multiplied the proceedings, but it caused the district court to expend considerable time and effort that could have been devoted elsewhere. Additionally, the court infers bad faith on Charles' counsel's part because the claims were completely without merit. Given the clarity of the controlling law at issue here, no reasonable copyright attorney, or even an attorney who had devoted 20 minutes to legal research, would have filed this complaint. Further, counsel refused repeated opportunities to withdraw the claims after warnings from defendants and upon the filing of multiple motions to dismiss. Rather, counsel's litigation conduct created unusually high costs and delayed resolution of this action. Apparently, counsel decided to roll the dice, despite dispositive binding authority. Crucially, Charles relied on the advice of his counsel, an experienced copyright lawyer, in choosing to press this litigation. Charles explained that his counsel's experience was reassuring and that he was given no reason to believe his case was objectively unreasonable. As litigation proceeded, Charles followed his own counsel's advice to ignore indications that his claims lacked merit. Even now, counsel refuses to acknowledge his error. These circumstances present a need to deter attorneys who fail to comply with their obligations to the court to research and put forth good faith claims and defenses. Charles himself need not bear the full brunt of the costs for which his counsel is responsible. The court, therefore, holds that Charles' counsel is jointly and severally liable for the fee award assessed against Charles. Calculation of the final award. Even accounting for counsel's joint and several liability, the court concludes that equitable considerations, fairness considerations, Charles's limited financial resources relative to those of defendants, chief among them, favor a significant reduction from the presumptively reasonable fee award calculated above. The court finds that a far smaller fee would adequately deter Charles and his counsel, as well as send a general deterrence signal, while still meaningfully compensating defendants. It therefore reduces defendants' presumptively reasonable fee by 90%, resulting in a final attorney's fee award of $28,750 and costs of $92. That reduction, while considerable, is consistent with the practice of other courts in this circuit that have had similarly reduced reasonable fees in light of limited financial resources. In further recognition of Charles's financial resources, the court also adopts defendants' proposal that, if Charles so chooses, the fee award may be paid in annual installments over the next 10 years to ease the burden on Charles and his counsel. Neither party addressed the matter of interest. Under the law, post-judgment interest is mandatory and running from the date of judgment. For the reasons above, the court grants in part defendant's motion for fees. The court awards $28,750 in attorney's fees and $92 in costs for a total of $28,842. The court awards mandatory interest running from the date of judgment. Charles and his counsel, Mr. Peter Skolnick, are jointly and severally liable for the payment of this award. If Charles so chooses, he may make these payments in equal monthly installments over a 10-year period. The clerk of court is respectfully directed to enter judgment. So ordered, March 25th, 2022, Allison J. Nathan, United States District Judge for the Southern District of New York. And that is truly a remarkable decision. Let's look again at what the total was up top. So we're talking about $973,000 total is the number that the defense submitted. That got reduced to $28,842, and that is a paltry 2.9%, 3%. That is a 3% of the requested fees. So I see two major things happening here. It looks like the Gibson Dunn attorneys billed excessively. It's my opinion. I'm not trying to state a fact. I'm not trying to accuse anyone of any unethical practices or anything. But it does seem like the Gibson Dunn attorneys used this case as an opportunity to incur lots more hours than was necessary to defend using a statute of limitations defense in a motion to dismiss. Honestly, if I had been defending Seinfeld, I probably could have done this for a few $1,000s. That's maybe overly pretty thinking, because there was a big threat here that millions of dollars could be at stake if Christian Charles won, but it still seems very excessive. So the judge pared that down to about $300,000. And then the judge said that because Charles is in terrible financial shape, that the number should be pared down further. So approximately a $30,000 fee on approximately $1 million billed. Yeah, that's incredible. So it's because of two things. It's because of the courts finding an excessive number of hours at an excessively high rate, and then pared down further because of Charles' ability to pay. And remarkably, Charles' attorney should never have counseled Charles to bring the case or pursue the case, which I think he filed pro se. Once the attorney came in, the attorney should have been saying to him, you shouldn't pursue this case because you're going to lose. And then if he did that, the attorney would never have been included in this award. So Charles and his attorney owe approximately $30,000 over the course of 10 years, plus interest. That's a very interesting case that really should never have seen the light of day. Let me know what you think of this one. Let me know what you think of attorney billing practices. What did you think of the excessive number of fees and the excessive hourly rate versus paring it down for Charles' ability to pay? Let me know what you think in the comments below. Thanks for watching. Special thanks to my top supporters in April: John Steele, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, Gutbrodj, ShadowTycho, Earthbound Star, PureMagma, Eric Tams, TechTechPotato, The Blood-Soaked Survivors, Wyatt Calandro, and King Aries. You can support Lawful Masses on patreon.com/ljfrench, sponsors.com/law, through YouTube memberships, and through Floatplane subscriptions. Join me for our weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all. Bye.